Hello, my name is Attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to answer all of your Illinois family law matters. So today's question is, my wife owned our house before we got married. Now that we're going through divorce, do I have any rights to the property? So this is actually a very, very frequent question. There are oftentimes cases where we have clients who come to us and they own a premarital property. That's what we would call it, is a premarital property. And the new spouse moved into that premarital property or premarital residence. And then they lived together for a number of years as husband and wife. And so for all intents and purposes, that premarital property was also their marital property. But there is an actual distinction between saying this is our marital home and our marital property, just vocally, and what the statute says and what the case law says. What the statutes say and what the case law also reiterates is that any asset that was acquired prior to the date of marriage, particularly when we're talking about real estate, acquired prior to the date of marriage, that is clearly premarital or non-marital party or asset. Meaning that when you go through the divorce and when you go through, the division of the debts and assets, that real estate is not going to be included in the division of the debts and assets. It will never be addressed in the divorce decree. It will never be divided between the two of you. She will not have to buy you out if it was a premarital home. So some people come and they say, you know what? I understand that, but I paid the mortgage from the day that I moved in. And what the case law says in response to that very, very common scenario is there's nowhere that you can live for free. If you pay the rent on that house, then think of it as paying mortgage, or think of it as paying rent on, any apartment that you lived in or any home that you lived in and rented prior to moving in with her. Just because you paid somebody's rent at your prior apartment complex or at your prior rental house doesn't mean that you could then take that property from the rightful owner, from your landlord. Same thing here. Just because you have moved into the residence and you have paid the mortgage, it doesn't mean that that property then commutes or changes or turns into a marital asset. It does not. It used to be that the case law would sort of vacillate and it would give different factors when a premarital property or a premarital piece of real estate would then commute and change into marital. Some of those fact patterns would be that the two of you bought the house in contemplation of marriage, or rather that she bought the house in contemplation of marriage to you. What does that mean? Well, it used to mean that she bought the house after the two of you guys were engaged. Perhaps it's because she had a better credit score or she had the verifiable income, but for whatever reason, the two of you guys decided that she would be the purchaser on the house. And when she purchased that house, the two of you maybe went house shopping together. You maybe were at the closing together and you were sitting in the lobby. You moved into the house together. You decorated together, did home repairs together. So all of those factors, especially in the aggregate, when we're talking about you moving in together, plus you paid all of the mortgage and you guys house shopped together after you got engaged. Those sorts of situations used to cause a situation where the courts would say, you know what? Although this is technically a premarital property, because technically her name is the only name that's on it, we're going to treat it as if it's marital. And we're going to allow, husband to be bought out of the house as if it were a marital asset. It didn't happen very often. It was definitely, obviously, the fodder of, a lot of litigation. But I can tell you now, under the current case law, it is extremely unlikely that under the fact patterns of this particular question about moving in to a residence that has somebody else's name on it, and even if you paid that mortgage for any number of years, it would be very unlikely that a court would find that you have therefore bought your way into getting any sort of rights to the house. So I say all of that to say, definitely beware, be cautious. I know that when you go into marriage, you're going in full of love and bright-eyed and bushy-tailed with the best of intentions. But in one of my other videos, I go into some of the reasons why Everybody should have a prenup, whether you have a large estate and a lot of income or not. And this is one of those prime examples. If you believe that this property, once you move in, once you get married and you start taking over the mortgage payment by yourself, should then be commuted and treated as a marital asset, then you can address that before you get married in a prenuptial agreement. You can even address it in a postnuptial agreement. But what you can't do is just expect the courts to sort of wrest that property away from your ex-wife and give you any rights to the property simply because that's where the two of you guys lived when you were married. So, very common fact pattern. I hope that this answers that question for everybody who's watching this video, and I look forward to seeing you on the next one.